Hello and welcome. My name is Deborah Gonzalez and this is Solo Practice University and the course of Intellectual Property. This is our last session for this course, and what I want to do is I want to focus on the very interesting, fun, and intriguing industries of film and television and the intellectual property issues revolving around that industry. As always, we begin with our disclaimer. This is for educational purposes only, not to be construed as legal advice. And if you have never done a project or a contract that deals with television or a film project, you probably want to make sure that you can find a mentor attorney who is in the industry, who's done a few of these, because there are some nuances that you do need to keep track of as we go through. I do have here in the handouts, make sure that you have them. I will not be going through all of the slides. There's quite a lot of information in there, but we will touch on mostly everything. But we will begin with some stats. We're going to be looking at acquiring rights for film and television, so story rights, live story rights, those kinds of things. We're going to be looking at certain contracts that you'll find in this industry, as well as some miscellaneous, and then we're going to go into television, and in particular I want to spend some time talking about reality TV and some of the legal challenges there. Okay, so if you have your handout, here we go. I wanted to start with some movie statistics. Now these are of course from 2011 because 2012 is not over yet. But you know, they talk about a market that's in the billions of dollars, right? Not just millions, but billions of dollars, 10 billion, 10.1 billion for the US market alone. And you're going to see in that stat which were the highest grossing films, and for 2011 that began with Harry Potter and the Deathly Hallows, the last installment of that movie franchise. So that became the biggest grossing movie of 2011. And you see some others there: Transformers, The Twilight Saga, The Hangover 2, Pirates of the Caribbean, Fast Five, Cars 2, Thor, Rise of the Planet of the Apes, and Captain America, the First Avenger. Yeah, there's no classics in that group, is there, right? There's no Pride and Prejudice. There's nothing like that in that group. So it does give you a sense of what the market is looking for when it comes to creating film projects, okay? Now, there are some major distributors, players in this market, and so that's our second slide with statistics. We begin with Paramount Pictures, then Warner Brothers, Sony Pictures, Walt Disney, Universal, 20th Century Fox, and then some that might not seem so common in terms of their names: Summit Entertainment, Relatively, Weinstein, and then Lionsgate. But it's good to know that these are the top distributors in this industry so that you know who the players are. The next slide talks about statistics in terms of genre of the type of film that's going on. So adventure is the #1 film. Now it's interesting to note that adventure may be the #1 type of genre in terms of grossing, but it is not the #1 type of genre in terms of production, the number of films that are actually made. That would be drama, 238 drama films that were made, but drama only comes in as #4 in terms of grossing. So even all those films, and it still doesn't equal just the 45 adventure films that there were. So it gives you again a little sense of what that industry is. And the last slide talks about the Motion Picture Association rankings. These are, you know, the PG-13s, the Rs, the PG, the Gs, the NC-17, and then the not-rated. And again, this is just to give you a sense of what is out there in the market and what is being promoted. So we see that PG-13 had 142 movies, R-rated was 210 movies. But even with that disparity, it was the PG-13 movies that gross the most, okay? So they gross more than the R-rated movies. So that, again, just gives you a sense of some of the players, some of the statistics, that how big this market really is when you talk about film, and that was basically film. And so the next thing that I want to talk about is who are the players in this market, in the industry? Who is actually doing being part of creating these films, distributing these films, or marketing these films. And so we begin always with the film studios, and these are like Paramount, Warner, Disney. We've seen them. Those are top distributors there. We have production companies, and these are companies that really focus on doing the recording, the production of the actual film. So companies like Miramax, Castle Rock, New Line Cinema, and Pixar. And then we have distributors. Now, these are companies that they do not make movies, they do not buy movies, they just distribute it. They're the channel through which the movie can get to all the different venues that it can go to. And so an example of this would be TriStar Pictures. So when you look at the movie credits in the beginning, it's not unusual to see, for example, Disney as the film studio, Castle Rock as the production company, and then in conjunction with TriStar Pictures, which is the distributor. And you usually will see more than one company, highlighted in the beginning. One of the reasons for this is that it's just so expensive to, one, produce a film and then to distribute it. I can remember they were talking about when Pierce Brosnan did his last James Bond movie, how it cost $200 million to make the movie, but it cost $300 million to actually market the movie and get it out to where it needed to be seen. Now, of course, that was way before social media and all of the new ways that companies are now promoting their movies. So it's interesting, but it still costs a lot of money. So it's not unusual to see companies sort of join together to be able to produce a film and then get it to market. We also have independent filmmakers, and these are sort of smaller studios. So here the example is Artisan. They don't have the big budgets that the film studios do, but every once in a while they'll have a breakout film that really makes tons and tons of money. So think of the Blair Witch Project and projects like that, movies like that, small movies made by independents, but still they're able to sort of get a buzz and get out there. Exhibitors, and exhibitors are movie theaters, right? AMC, Regal Cinemas, we're seeing much more in terms of how they are evolving. Out here we now have what's called the tavern cinema, where you can actually go and be served a full dinner as you're watching your movie. And so it sort of combines a restaurant and a movie theater. And we're seeing how these exhibitors are evolving to offer much more, sort of enrich the experience of the movies because it is getting so expensive. So the idea is, how do you give more value to the movie fan who's going there so that they don't feel that they're being taken advantage of and that they really will spend that money to go. We have festivals. Now, you've heard of the big ones like Sundance and the Cannes Film Festivals and Tribeca, but there are festivals just about in every major city in the U.S., but also, colleges and universities may put on a film festival. Different churches might put on a film festival, different organizations, community organizations might put on a film festival that sort of around a particular theme. Festivals can be very, very important. The bigger ones like Sundance and Cannes, they give a lot of credibility to the movie that's coming out. It sort of creates an extra buzz. Awards are given at the festivals, which is why movie makers really try to submit and get accepted into these film festivals and maybe even win a particular prize. Some festivals are based on genre, so there are lots of, for example, animation festivals that will only accept animated pieces versus a bigger festival like the Atlanta Film Festival that'll take a little bit of different genres. Okay, so it's very important that if you have a client who's looking at putting their projects into festivals, that you understand what the theme of the festival is, what the purpose is, what the criteria for admissions is. That is really, really important. You want to make sure that you're not just submitting it to all these different festivals that really would not be the right audience for the project, because each festival does have an entry fee, and so that can get very, very expensive. Besides having the film screened at the festival, there also might be an opportunity for the filmmaker to go and sort of speak to the audience, sort of promote the movie in other forums within the festival itself. So it can be an expensive endeavor. So you really want to make sure with your clients that they know which festival they're going to and why they want that particular festival, and to make sure that their project matches what that festival is all about. And then there are also organizations like the Academy of Motion Pictures, Arts and Sciences, and others, guilds, and the Screen Actors Guild, for example, and other unions that are involved in the whole entertainment industry. And of course, there are also the talent, right? The actors, the extras, all of those, and that really falls under a lot of the union work there. And we'll talk about that a little later on. Okay, so when we first begin, any film project begins with an idea, and the idea has to be submitted to an entity that can actually either make that idea into reality or get the people and the places together to make that happen. And this is the same for film as it is for television, okay? So we also have to realize that under our copyright laws, ideas are not protectable, right? Only something that's in a fixed form of expression is protectable. And this can create some real controversy when a movie or a TV show is based on an idea and not based on, for example, a already published novel, okay? Or a song. We've had movies based on songs, for example. But if there's nothing that it's really based on except for an idea, we have to look at how do you protect the idea when you're trying to get people interested in order to produce it and put it into a fixed format, okay? So when we come to idea submission cases where people claim, you know, I gave them the idea and they stole the idea from me, we usually find two types of cases when it comes to idea submissions. The first one is circumstances that must exist in order for a contract or confidential relationship to exist between the person who submits the idea and the person to whom the idea is submitted to. And then the second one is once that relationship is found, the characteristics of the idea that can be protected. So in other words, we look at first at the relationship between the person who has the idea and who he's telling the idea to, who supposedly stole the idea, right? And then we're looking at if there is some kind of relationship between them, if there is some kind of understanding, whether it's because of industry standard, whether it's because a contract exists, whether orally or written, okay? But if there is that relationship where there is a duty between the two of those parties, then that idea, was it anything that could have been protectable? So for example, if it's something that's considered, you know, just a traditional standard plot, the court's not going to hold that there's been any stealing of ideas or copyright infringement, right? Because take, for example, and we might see this a little later on when we look at different aspects of old storylines that then get remade, right? They get remade, and if the person didn't have the rights to the original, the remake might take on a whole different format than what it originally looked as. Okay, so we have this case that I wanted to bring up in the next slide. It's from the Hollywood Reporter. The Hollywood Reporter has a section called Hollywood Esquire, and it is a wonderful place to sort of see what the new cases are coming out that deal with entertainment and law. So this is something that you want to bookmark and check out every once in a while. It's Hollywood Reporter, Hollywood Esquire. So here's a story that came out. This was Kurt Sutter wins lawsuit claiming Sons of Anarchy was stolen. And this is an interesting one because we went back and forth with this case. First, the court said and sort of agreed with the person who the idea was submitted to, the ideas are not protectable, and therefore there was no copyright infringement. But then on the appeal, the court came out and said, yes, there was an expectation that there would be confidentiality ensured, that this was an idea that was submitted, and everybody knew that the person who submitted it did want to get paid for this idea. And so that court said that, in fact, the person who claimed that the idea was theirs and that the idea was stolen from them actually won that case. But there's a lot of nuances on that, so you definitely want to read up on that. The next one that I brought out is one that deals with ghost hunters. The case is Motz versus Pilgrim Films and Television. It is a case from 2011. It got to the Ninth Circuit in March of 2011. And it talks about, for the first time, that damages can also include profit splitting when it comes to this kind of idea theft. And so what they're saying is it's not only about, how much profit did you make, but also if it would have been understood that the person would have shared in the profits by it being split, or a percentage going forward, then they may also be entitled to that. So that's another interesting case, specifically when it comes to damages. Okay. We do have here just a summary of some California law when it comes to idea submissions. You have a link there, Copyright versus Idea Submission article. It's a 1998 article, and you might say, well, 1998, it's been over 10 years. But actually that article has some really great fundamental basics. If this is a totally new area for you, it is recommended reading. And what it does is it lays out, if you can't say that this was copyright infringement because you don't have a copyright registration, or if it was spoken, it's nothing in writing, then this is a wonderful basis to take a look at to see whether you do have a claim for idea theft. And so they talk about this list of elements, and they begin with, first of all, there has to be an idea, right? It's just not, oh, well, I want to talk to you about something. There actually has to be an idea conveyed. The idea needs to be offered for sale. So it's not like, let me just tell you about my idea. It's more like, I have an idea. I'm interested in seeing if you would want to produce it. I'm in the market. I want to sell my idea. There has to be some conversation that the person who has the idea has an expectation of being compensated for that idea, that he was just not giving it away. The person receiving the idea must reasonably understand that the person who's giving him the idea expects to be compensated. So again, it's this idea that you have to be, explicit in saying that you want to be paid for your idea. It's very, very important. And then the defendant has to actually use the idea. So it's not just that I told you about it, I told you that I want to be paid for it, but then you went ahead and you used it without paying me, and you made the movie, you made the television show, okay? And that there was no independent creation. Because remember, the copyright laws do say, we can, in fact, have two people who come up with the same idea, totally different parts of the world. So you have to prove that there was no independent creation, that they did it only because of the idea that you had submitted to them, and therefore it is true theft. So here's a great, another great case. This is a fun case. Usually when I discuss this with my students, I bring M&Ms to the class. This is Vent versus Mars Snack Food US, and it is about the M&M's Addams Family commercial. And this woman came to the M&M's company, and she said, the Addams Family movie is coming out. We're close to the Halloween period. This would be a wonderful tie-in for your M&Ms for a commercial, and you can just sort of pretend the M&Ms are different personalities of the Addams Family, and then sell and make a commercial out of that. If you Google on YouTube M&M's Addams Family commercial, now even though it is from 2009, it should still be on there. It's 30 seconds, and you can see it, and you can see the commercial that was actually made. She claimed that this was her idea. Mars claimed that no, it was a generic idea, and it was pretty standard to think of. October, M&M's, the Addams Family, those were all things that anybody could have put together. We did not take it from her, and so she did lose the case. M&M won it, but you get a chance to see it. And also, if you want to see another take or parody on the Addams Family, there's another one that you can Google on YouTube called The Legos Addams Family and see them do that theme song with the snaps and everything. Okay, so it's a little bit of fun. It's a fun case to review and go over. And so we have some example here. This was a New Jersey case. So basically, Vent would sue for misappropriation of an idea in New Jersey. That was the cause of action that was there. The elements that the court looked at in that particular case was the idea novel? And this is where they were saying, no, it wasn't really novel. I mean, anybody can put these elements together. Was it made in confidence, and was it adopted and used? And the court held that, it was not novel, that she did not convey it in confidence, and there was no confidential relationship between the individuals. And they also made this note. They said, Mars, because she made the claim, the plaintiff made the claim, well, this is the entertainment industry, and they should know that individuals expect to be paid for their ideas. And the court came out and said, Mars is not in the entertainment or marketing business. They produce candies, so they are not expected to know or abide by entertainment industry standards. And I thought that was really interesting for them to bring that up. And, maybe if she had sued the marketing company that had created it, right? I just thought that little tidbit was very, very interesting when it came to, they're not in entertainment, they're only in making candies. But, they do have a marketing firm. So it was an interesting case, something to take a look at, something to take note of. Okay. So now with a little bit of that background of ideas and stuff, I want to talk a little bit about some of the history so that you can see how the law sort of progressed as the film industry evolved. So we started with films with the studio model, and here the studio sort of controlled everything from getting the talent to specifying the story to producing and taping and recording the movie, to then distributing the movie, and even sometimes in owning some of the movie theaters that the movies were shown in. Okay, so the first film is actually filmed in Fort Lee, New Jersey. 1907, Thomas Edison's film was rescued from these eagles' nest, and so you have a little link there if you want to start seeing some of that. In 1920s to World War II, studios controlled everything, as I said before, but then after World War II, we get this antitrust litigation, which basically says, the movie studios, they control too much. It's too much of a monopoly. It's not fair because they can do whatever they want and not leave space or time or resources for others, and it becomes very high level of entry to get in there. And so after the antitrust litigation, what we end up with is, instead of a studio model where, actors and directors are sort of locked into contracts with a particular studio, we now have sort of this film by film model, which is what we have today, where actors, can take any particular film that they want. They sort of serve as free agents, the same as the directors, right? They're not locked into a multi-deal contract with any particular studio. Now, that may happen sometimes for a particular movie franchise. So think of The Lord of the Rings, for example, where they were given a contract for 3 movies, right? So if the first one was success, then they would be obligated to do the next 2 movies as part of that. Twilight had the same thing. Harry Potter had some of that. And the idea of those multi-picture deals are to make sure that the characters remain the same and that there's consistency within that. So if you think of the Pirates of the Caribbean, for example, 1, 2, 3, you had Johnny Depp, you had Keira Knightley, and you had Orlando Bloom. When it came to Pirates of the Caribbean number 4, Orlando Bloom and Keira Knightley were not in that one, right? But we did still have Johnny Depp, and that's because that multi-picture deal was already over for Orlando and Keira. Okay, so that just gives you a sense of the changes that have happened. Okay, there's a lot of things that sometimes happen before even a movie gets to the set to get recorded. One of the things is, of course, that studios need to make sure they have the funding in order to go and be able to produce this. And one of the other handouts that you have in this month's session is this filmmaking and the law checklist. And this is just a quick checklist. I got a lot of this information, and you're going to see where the information was compiled from, some of the places that I took information from. These are all great links. You want to go there. But this is just a very quick checklist of things, preparing to produce, then financing, IP, production, pre-production, post-production, just some of the legal documents that are required for each of these areas. So I thought that might be a good resource, especially if you're new, sort of like to keep that as a checklist. You might be overwhelmed at a certain extent when you see all of these kinds of key documents, but it is a great way to sort of get a sense of the scope of all the legal issues that go into actually producing a film or a television show in those, okay? There could be some co-financing agreements with studios. If you remember, I mentioned before, it could be very, very expensive, and so studios may actually want to work together to sort of keep those share in the expenses. And then the idea of investors, using outside investors. And with that, I want to bring up a couple of things that came up. The Jumpstart Our Business Startups Act, the Jobs Act, which was enacted in April 5th, 2012, okay? And it was talking about, currently it's unlawful for a filmmaker to send out email blasts to strangers or to advertise on the internet to attract investors. And so this sort of became a concern because people are using these crowdsourcing websites, things like Kickstarter and Indiegogo, you might have heard of them, to sort of try to find financing for their initial, much smaller projects. These are not major studios doing this, right? These are small independents trying to get some money to make a film. But this Job Act actually does affect the idea of soliciting investors and finding out, just for example, who is an investor, okay? And so you can just Google update on soliciting investors, Entertainment Law Resources blog. It sort of gives you a little bit of information on what's going on with that. The SEC still is looking at, hasn't given their formal opinion on this particular bill, but it's very important to keep in mind because it does affect how films are being financed. And so it's just an important issue for you to keep in mind for that, okay? So now what I want to do is I want to take a look at acquiring rights, because everything begins with a story that needs to be told. So how do you get the rights to that story? Sometimes it's an original pitch. It wasn't written anywhere before. It's just an idea somebody has, and so they want to give a pitch for that. Sometimes it's based on an existing play, book, screenplay, or treatment for a screenplay, and there are different sort of documents when it comes to presenting your idea for a movie or a television show. We talk a lot about the pitch on paper, okay, and this is sort of a no more than 2 pages that talks about the core elements of the particular show or film that you want to get created. These can also be not only registered with the Copyright Office, but also registered with the Writers Guild of America. And again, being able to say, look, it's registered, it's deposited with the WGA, sort of gives some added protection before your client goes into a pitch meeting, for example. There are things called option agreements, and option agreements are, basically for 1 year, and then they have extensions, options of extensions for another year. Maybe it might renew for 3 or 4 years. And basically, an option agreement states that this producer wants to option the book, the play, the idea. He wants to have exclusive uh, ownership of some, rights to a certain extent for a particular amount of time, like a year, so that he can go and find a production company, find some talent that might be interested, find some funding that may be interested in producing this. Okay, so the option agreement is basically so that the producer feels secure that he's the one who's going to be shopping this. There's not going to be 5 other people shopping this same story. Okay, so he pays for the option, and it usually does have some exchange financially, and it all depends on how valuable the underlying property is for the option. Now, if it's a bestseller book, for example, that's had a lot of buzz, the option could be quite expensive, right? And people might not even just option it; they might just buy the movie rights right off the bat. So you do have to be careful at looking at what is the value of the property in the marketplace when you make a bid on the option agreement, okay? The broadest rights to distribute in all formats presently known and may be invented. The reason why that is there is sometimes when you have an option agreement, some of them may be very specific, option for a movie. Some of them might just be much more broader to option in any format that the producer might be able to secure for this particular property, okay? Okay, other things to keep in mind is that there is a difference between domestic and international release. The home video market, broadcast and cable television, and that includes, when we talk about cable, it includes pay-per-view or on demand, and internet streaming. So things like Netflix and Hulu, those are now becoming other ways that people are receiving this kind of content, and in their different devices, whether it's a laptop, an iPad, another tablet from Samsung or anyone else, a Nook, or how they connect it through their television, okay? One of the other things to keep in mind with any of these option agreements and how you're acquiring rights to be able to tell these stories is make sure that you also get the rights to the characters that are embodied in the property, because that way you can do a remake, or you can do a sequel or a prequel or spin-off or any kind of derivative work. So it's not just being able to claim rights in that story itself, but also to claim rights in those characters that are doing the story. So on our next slide, we have some information of just some things to take a look at with the literary option or purchase agreement. And again, literary means that there's a book or a play, something that's been printed and published out there already, and that this film is then going to be based on that. There are things that you need to take a look at, like the length of the initial option period and any extensions, and to know whether if any of those sections are just automatic at the end of the year, unless somebody said, no, I'm not going to renew it, then it just automatically renews for that option, or if maybe there have to be some conditions met before the option is renewed. So for example, securing a certain amount of funding before the option can be renewed. Okay, so it's very important to look at that. The price of the option periods and extensions, so maybe the first option period is one amount and each extension might be another amount, or the price for the extension may be open to negotiation at the time of renewal. Okay, so it's important to take a look at that. Will there be any setup bonuses that are included? Does the purchase price include all the rights, and or what specific rights if it doesn't include all the rights that you're asking for? Are there additional writing services to be rendered? So for example, if you have, you've purchased the option for a novel, would you then require that the author help in terms of the conversion of the novel to a screenplay? If it's a screenplay that has been optioned, does the screenwriter still need to be around to do certain rewrites of the screenplay as the production goes through? So those are additional writing services, okay? reversion of rights. In other words, if, let's say, you have this option and after the original option period and maybe the first renewal, if nothing is done, can the rights then revert back to the original author who sold those rights? If there are rights of first negotiation and matching rights, and also what are the credits? And if you've never done credits before for particular titles in movie and television, the Writers Guild of America is a great place to go and look at the way that they outline credits. So I went there one time. The first time I ever went there was to look at producer credits and the difference between a producer, an executive producer, a line producer, an assistant producer, etc., etc., etc. So they really lay it out very well. And so again, if you're new in the industry and you're not sure who does what, going through the way that they list the credits is really going to be a great educational experience for you. So you can find them there. You will need a memorandum agreement. It should have a grant of rights. There are going to be some representations and warranties, right? So the person who is optioning this has the right and the authority to option it. The person who is, granting the rights warrants that he is able to grant those rights, that there's nobody else to have a claim, indemnity, all sorts of issues there. For representations and warranties. So think of your standard contracts, right? Those are going to have those clauses in there. A master use license for music. This is very important because music is a big part of setting the tone and the ambiance and creating sometimes the whole environment or the whole sense of that particular movie. So it's very important to know, is this going to be original music that's composed just for the movie like some of the soundtracks are, or is it going to be using popular songs that are out there? So you do need to take a look at that because each of that music is going to have different copyright rights, as well as different royalty payments or different licensing agreements that need to be put in place, as well as film synchronization and performance license with the music publisher. So you might have to acquire the rights, not necessarily from the musician or artist, but from the publisher who's publishing the music and representing the music. So it really is important to take a look at that. Okay? Okay. So now that we're back, I want to look at some other kinds of agreements, other kinds of what we call, or to begin with, the RF&D deal, the production, financing, distribution deal, okay? And here we see that a studio will engage a producer to oversee the development of a script. It could be a new script. It could be a script that they've actually had for a while. They might have even had a different producer or a different director, and then the project just did not work, and they needed somebody to sort of take a different track with it. The producer becomes responsible to recruit the director and other lead actors. And so the producer at this point is really putting pieces in place. Then he will take that back to the studio, and the studio will decide whether to go forward and produce the film. So you hear the term green light. If a project was greenlit, that basically means the studio said yes, and then they will decide how much funds to put into it, if it's funds for development, if it's funds to finance the actual production of the film. So those things will need to be in place. The studio usually has the right to review and approve the budget, the shooting schedules, and all the creative elements. Now, sometimes it's negotiated with a very well-known director. For example, let's take Steven Spielberg, who'll be able to sort of request certain things in his contract, like he'll want creative control over creative elements and those kinds of things. But those are very specialized individuals who are just so well known in the industry. Steven Spielberg also has his own production company, so sometimes that'll make it easier as well. He'll have even more control over that, and that's not unusual. You'll see actors who will create their own production companies. That way they have more control over the film projects that they are actually part of, okay? The studio may also have the right to abandon the project. It may feel that there's just not enough happening, or it's going too slow, or it's being too much over budget, or there's just too many problems. We had a recent issue in the Hollywood Reporter about a film project called Rebecca, and how that has been sort of canceled, and all the legal ramifications and stuff that's coming out of that cancellation and what that actually means. So you can Google Rebecca and just take a look at all the things that happen when a movie is then canceled, okay? The movie will also, the movie studio also tends to keep control over decisions as to distribution and marketing. And sometimes the studios even have a marketing department who will take care of the marketing, and they will then be able to control the marketing budget a little bit better. Just through economies of scale, right? Since they're putting out all of these movies and doing that, so they might be able to control marketing as well. The studio then owns the right to the film and in the underlying property unless it does not produce the film. So the final movie, right? The final movie that we see on the screen, that's actually owned by the movie studio because they're the ones who produced it. Now, what about when there's co-financing agreements? All of that, all the IP rights in the final result, the final movie, are laid out in that contract when they do the co-financing. Okay, usually you'll see where they decide whether it's going to be a royalty split or how is it that they're going to do it to own that. Okay, now the producer is usually exclusive or at least on call once the shooting begins. So it's not unusual for a producer to say, I'm non-exclusive pre-production, I'm non-exclusive post-production, I'm exclusive to the project during the actual production, okay? Producer fees can be anywhere from $100,000 to $2 million. Sometimes more, depends on the caliber of the producer themselves. The average lies more into the $300,000 to $400,000 mark that you see there. Plus, there's usually a percentage in the contract of a predetermined net that talks about what happens when they get their first gross dollar after the break even. Sometimes some of these monies are given as an advance to the producer, and so he doesn't really, since he gets that money up front, he doesn't really get much more afterwards until that money is sort of like recouped or repaid, okay? The pre-production budget, full cast, and in pre-production, basically what you're doing is you're laying out the budget, you're finalizing the cast and the crew, and both of them are important. The cast are the actors, but the crew can be just as essential, and the crew can be anyone from a grip boy to people in makeup to your catering service. So those are all also very important to have identified. The locations are usually scouted. We see many states now that even offer incentives to film production companies so that they can come in and get some tax credits if they film and produce their project there in that state. So Georgia, for example, has a 30% tax incentive up to, I think it's like $300,000 in $1 million budget. So there's a lot of production happening in Georgia because of that, because of those incentives. And some states have them. You have to do your homework if your client is looking for a place to go and film on location. The other thing that's great about states that have these incentives is that usually because they have the incentives, they also have other infrastructure in place to help production companies, number one, find locations to shoot at, be able to help them with logistics, everything from hotels and lodging to transportation. So they also have a talent pool of actors and a great pool of crew, and they have, supporting industries that can help the production once they're on location. So it is important to take a look at that when you're looking to film on location. Costumes are being made, props are being acquired, actors begin to rehearse the scenes. We have a read through at this point for that. Principal production really talks about the actual shooting of the film, okay? And that can be anywhere from 24 hours. They did a film, I don't know if you remember Colin Farrell's film where he was in a phone booth basically for the entire movie. That was filmed in just 24 hours. It was a shoot straight. Or you can have films that will take months and even a year or so. So Lord of the Rings, even though it was 3 movies, they were basically filmed one after the other. So that took over a year of principal shooting. But it could be just 3 months. It all depends on the complexity of the movie, how many locations they have to go to, everybody's schedule, the actors, and that sort of thing. And then there's post-production, and post-production is everything that happens after the main film shooting has been done. So any of the, special effects, they might call in actors to redub a line, for example, or to check out the dialogue. The distribution department begins now. The trailers and the billboards, the commercials, and press releases. You see the actors going on personal appearances at this point, and a lot of social media and online fan sites are going to get involved. So those are the 3 stages, right? Pre-production, production, and then post-production. Now, we saw what the producer is. Let's take a look at a writer's agreement. And here it's going to specify the writing services that need to be performed, the writing periods, any payments for each writing steps, and certain guarantees. And very important are the credits. What kind of screenplay credits will the writer get for doing this writing for it? It'll talk about royalties, the different credits. Most of the time on many of these big projects, especially studio projects, the writer needs to be a member of the Writers Guild of America, and that's the labor union for professional writers. Now, there is an East and there is a West WGA, and if you haven't heard of them or you're not familiar with them, you can just Google Writers Guild of America and up will come their website, and you'll be able to take a look at all the ins and outs of what they offer their members. And it is important because once a writer becomes a member, it gives him some benefits, but it also restricts him in a certain extent because, for example, he can only then work on projects that are signatories to the Writers Guild of America basic agreement. So, if a project isn't going to be with unions or isn't going to do any of those kinds of signatories, then that might be a problem when it comes to having a WGA member actually be the writer for your project. Okay, and at the end, the WGA is the one who determines the writing credits for the film based on once the writing is finished and what has been produced to them. Now, one of the things that happens is that many people like movies that are sort of based on the truth or based on fact, and a lot of them are based on either an event that occurred or on the life of a particular person. So being able to capture those life story rights are very important. And so the idea, though, is that when you get the rights, you're going to notice that there's also going to be some concerns. So, you don't want to be sued for defamation or invasion of privacy or violation of any publicity rights when it comes to telling someone's story. So some people say, well, if I take the information just from news sources, for example, then I shouldn't have to go and find the life story rights. Versus if I'm going to do it from that person's point of view, then I really do need the life story rights from that person because that person is going to tell me things that I would not have been able to find from the newspapers, magazine articles, and other sort of open public documents, open records, okay? And this is usually life story rights also done on an option agreement platform, and you notice that they'll lay out, the option period, if there's any extensions, the price, a lot of the other things that we've seen from the rights and the acquiring the rights that we looked at before. But one thing is, when it says rights granted, I want you to take a note of this in your handout where it says can be specific to a specific period in a person's life or specific events. So it doesn't necessarily mean the whole person's life. It could be that that person was only, renowned for a particular thing that happened or occurred during that life. And so you really have to make sure what rights you're getting to that person's life in a way when you have that option, okay? So you want to be careful of that. Also, if let's say an example would be that it's about the life of an artist, so there are copyrighted works maybe that that artist created, let's say painting. You have to secure the license to be able to show that copyrighted work in the film, and so you need a clearance for those. So that can be very complicated and tedious, right? Making sure you have the right to use any image in that particular movie or TV show. So you want to take a look at that. Our next agreement is a screenwriter agreement. You do have in the handout the elements there, the grant of rights, representations, indemnities are very important. You're going to see them throughout all of these contracts that, the screenwriter indemnifies the producer against defamation for what they've written, etc., etc., etc. Any type of terminations. Also notice that here insurance can be an issue, and we see them in other contracts as well. And then immigration naturalization. This is a topic that can be very important depending on if your screenwriter is from another country, if he's working here. It's very important to understand what the rules are. So if it's a person, for example, who's on a certain visa to work for a company, they cannot necessarily just write your screenplay or write your pilot. So it's very important to know and to speak with an immigration attorney to make sure that those issues are taken care of. And then, of course, publicity, rights of publicity, because you may want that screenwriter, the same as the director and the producer and the actors, to be available to be able to promote the film that they have made, okay? So in director's agreements, we have basic terms, and then we have standard terms. And then now let's take a look at some talent contracts, and these talent include the performers and the actors. And one thing to keep in mind is that a talent contract is like a personal service contract, right? It includes the acquisition of rights owned or controlled by the talent themselves. Many of these are long-term. They may or may not be exclusive, and they're usually on a project-to-project basis, and long-term for the life of the project, right? If they sign off, then they need to complete that. And basically, the idea is that the talent contract is a personal service because the talent is unique, intangible, and often highly idiosyncratic talents of individual performers or artists. So in other words, you're hiring this particular actor to do this role in this film. I did not want anybody else. I wanted that person. And so that's why the contract is written in such a way that that person is giving their personal service, right? If you want Christopher Walken, you do not then want Jeff Bridges. You want Christopher Walken to do it. Okay, so you want Christopher Walken to come in with his style, his idiosyncrasies, put his gist on that particular role. Okay, so it's very important to understand that, because sometimes when there's a breach of contract on the part of the actor, right, and the actor will then say, I don't want to do this or whatever, it really does cause a delay for that film, because the casting director and the producer and the regular director, they probably envisioned that actor in that role. And so we do have a lot of cases that come out from actors who decide that they're not going to do a role. An example of this would be, I believe, Kim Basinger in a movie called Boxing Helena, which was about a young woman who is sort of kept secluded in a home, and a doctor sort of cuts off her arms and her legs to keep her stationary. And Kim Basinger decided that she did not want to do that film and broke the contract, breached the contract, and there was a big lawsuit about that. Okay, so in the performer agreement, you're going to see that it's going to specify the particular services, the kind of rights that that performer gives over, the compensation, representations and warranties and indemnities, of course, those are all standard. Credit, producers control, lenders remedies, and then suspensions and terminations. You'll see that it also will continue with insurance and the immigration issue that I spoke about recently. Expenses, whether that means wardrobe, hair and makeup, all different, travel, if the actor is also has another commitment somewhere else. Publicity, always the actors, especially the lead actors, are required to sort of make sure that they can do some publicity for the film that they've just starred in. Also, if they're part of a guild or a union, and then any negotiated perks. Okay, and negotiated perks would be like, well, my trailer's going to be this size, and I need to have 2 personal assistants, and I need to have, hot chocolate every morning at 7 o'clock as soon as I get in, and those kinds of things. Sometimes some of these negotiated perks are put in there to see if the other party is actually listening to what's in the contract and paying attention. Sometimes they're just what that individual actor feels that they deserve. Okay. Some other things that may come up with performer agreements are things like the nudity rider, consultation rights, and wardrobe. Nudity rider, not all actors and actresses agree to be nude, and so they might request a body double, or they might say, you can show me with a brassiere, but not totally topless. So there are different things depending on who the actor or actress are, and those are usually negotiated individually. Consultation rights, if there is a particular area that person is really an expert on, that they might be able to offer some consulting services for that. So a lot of historical era type of movies will have consultants on board to help them get it with some historical accuracy. We know that historical movies are historical fiction most of the time, and will have, for dramatic effect, introduce things that did not really happen in that history, but it's there for the dramatic effect. And wardrobe, there could be some clauses that say that the actor or actress may take a few pieces of the wardrobe, or may not, or may have one piece of the wardrobe, but the wardrobe is the property of the particular studio. So it is important to lay that out. We have had scenarios where an actor or actress was sued because they had taken pieces of a wardrobe that it was in the contract that it was going to be property of the studio. So you want to get that clarified as well. Okay, and especially now where the aftermarket for movie memorabilia is becoming so large. People, that we have collectors out there who will pay huge sums of money for a prop or a piece of clothing or a part of the wardrobe from the movie studios, that it is a way sometimes that some of these studios recoup some of their costs is by selling these props. So you do want to make sure that you see what's in that contract regarding those. Okay. Now, another issue are contracts with minors. Many of the movies have children in them, a minor under 18 years of age for most of the states that are working in this. And usually the problem is that a minor can disaffirm a contract generally, but they cannot disaffirm if the contract was also signed by a parent or legal guardian. So sometimes what you'll see is that there's a contract for the minor child, and then there's a contract for the parents themselves. And so we have some clauses here in your handout. One of them is a clause where the parent may relinquish custody, control, or earnings of a minor. A covenant that the parents will not interfere with the performance of the minor's services, and sometimes the parents have to guarantee the obligation of the performance by the minor. Okay, so I'm sure you've all heard of the nightmares of having, the moms and dads on set, but sometimes they're also there to protect the interests of their children, but also sometimes serve in a management capacity of their child, and so to make sure that they fulfill their obligations on the contract, okay? We have some codes here from California and from New York. I just wanted to give you some examples. Codes are by state, so you do want to make sure that you look at what the codes are for the state where your client is actually filming, okay? And the contract with minors, the California Family Code Section 6750. Okay, court approval is required for minor contracts and restricts then the minor's ability to disaffirm the contract. Obviously, this was a way of getting around minors who just decided, no, I'm not going to agree to this. It's usually between the minor and the talent agency. Okay, Section 6752 brought up the issue of Coogan Trust accounts. This was a 2003 amendment which requires that a certain amount of the money must go into a trust account for the child when they reach majority of age. And that was trying to prevent what happened with Coogan, who was a child actor where his parents took all the money and he ended up destitute. And so it's trying to prevent that. And it can be up to 15% of the child's gross income that is required to go into that. We just had an update in September of this year. The California employment law passes a new law about employment of minors, and it's California AB 2396. Okay, and this is specific to minors under the age of 16 in the entertainment industries, and even more specific, looking at the employment of infants under the age of 1 month on a movie location or set. Okay, and for example, it requires that a pediatric physician has to provide written certification that the infant is at least 15 days old, that the infant was carried to full term and was of normal weight, and that the infant is physically capable of handling the stress of filmmaking. Okay, so that one is really focused on using infants in the movie and making sure that they're going to be taken care of and there's not going to be any problems. Okay, so in New York, we have the Child Performer Education and Trust Act, and again, they set up a trust account, 50% of the child's gross income. New York also requires that there are some educational standards that the minor must meet, and so film crews and the studios must provide tutors and the such so that the child receives their education. Okay, so that's New York Labor Law, Section 152. And then there's the New York Arts and Cultural Affairs Law, Section 35.03, focused on minors in entertainment, arts, and sports. It says that you need judicial approval of contracts with minors, but it's not required if the contract is reasonable and provident to the minor. So if it's actually a good contract for the minor, you do not need court approval for it. Okay. An update on just labor agreements. The Screen Actors Guild, SAG, and the American Federation of Television and Radio Artists, AFRA, had merged in March 30th of 2012. So where we used to have 2 unions, we now only have one. It's called SAG-AFRA. And if you don't know anything about unions, it is a lot of the employment law side of it. This is very specialized, so you might actually want to work with someone who has experience with those. Okay. Now let's talk a little bit about the financing side of it, gross receipts and net profit. There is something called points, and above the line personnel, those who are usually top talent, producers, directors, people at that level are concerned about points. And points refer to how much revenue participation there will be beyond a fixed fee, okay, once a particular condition is met. So in the example that we have here, Captain Hook, there was Dustin Hoffman, Rob Williams, and so they said they would get 10% of gross once 100 million in revenue was reached, okay, and then that would come in. So besides the fact that they were going to get a salary, then they'll get a percentage of the gross after that condition is met, which meant they had to sell at least 100 million in ticket sales. This is done sometimes when there is a project that is very talent heavy, and it would just be too cost prohibitive to be able to pay all of this talent uh, all their compensation. So think of Ocean 11, Ocean 12, Ocean 13, all these actors that were there, all these top name actors. None of them were really compensated until afterwards. So they didn't get a salary like they might usually. You'll hear, oh, they got 20 million to make this movie, but they did get a percentage afterwards. That's how they were compensated. They weren't compensated with a salary. Okay? Here, the idea of that there are, how do you calculate some of these numbers? There are accounting firms that are specialized, CPA people that are specialized in doing just the accounting and the bookkeeping for these kinds of film and TV projects. And it's something that you can certainly recommend to your client, that if they don't have anybody on board that really knows about this kind of bookkeeping, that they really should be looking at hiring somebody for that. Gross studio receipts include everything from ticket sales in theaters, TV licenses, but then it also includes things like home video rentals, soundtrack record sales, music publishing income, and even merchandising. Okay, so when they're talking about gross, they're talking about way more than just those ticket sales in the theaters. It is everything as it relates to that movie. So think of merchandising that can be very, very lucrative, especially for children's and family television or film projects, right? So think of Disney. Disney once said, they don't make their money out of the movies, they make their money off the licensing and the merchandising. I remember when my girls were young and Pocahontas came out, of course they got the Pocahontas sandals for them and the Pocahontas costumes and Pocahontas ice cream. Everything was Pocahontas, right? And I'm sure if you have kids, you have your own example, whether it was Little Nemo, Cars, or any of the myriad of these children's movies franchises. There was merchandise to go with it, okay? From that gross, we then deduct things like distribution fees and distribution costs, any production costs, if there were deferrals. And deferrals mean that, if you agreed that you were going to pay somebody a certain amount, but it wouldn't happen until after the gross came in, those are our deferrals. And then if there are any kick-ins for the net, that's going to be included there, okay? So another big thing that happens with film and television is this idea of insurance. And there are all kinds of insurance that are required for the production to begin, okay? There's general blanket insurance, and then there's insurance for the individual project. So a studio may have insurance, a producer may have his own professional liability insurance, but then he might be also required to get insurance for that particular project. Sometimes you need extra insurance. So these are just some examples, like if you are filming in a dangerous zone such as the Middle East, sometimes you can't even find insurance to do that. No company will touch you because it's just too dangerous a place to go and film. Actors doing their own stunts. This can be dangerous because even though, some of the actors say, yeah, I can do it, and sometimes directors, they want their actors to do it, but if your main actor gets injured and is then out in the hospital for 2 weeks or 2 months, it can really add up to the cost of that film. So sometimes this is the reason why they won't allow the actors to do their own stunts. And you see here, sometimes even they'll require that actors not do extracurricular activities. This example is like flying planes because, again, it could be dangerous if they have an accident that's going to delay the entire project. Okay, cast insurance to cover death or incapacity of principal actors. If anything does go wrong, say they do their own stunts and then they break a leg or, become paralyzed, this insurance will cover that. And essential elements insurance is going to be important. Okay, then there's general insurance for theft, damage, or injury to just regular cast members and crew, workers' compensation insurance for the crew, weather insurance in case it rains and just production is delayed, but not just rain, but other kinds of weather that would just, make everything stop. I can remember looking at the Weather Channel at a little show that they were talking about storm stories, and they were talking about the production of Jurassic Park, the first movie in Hawaii, when they filmed that, and there was a big hurricane that came through there like the day before the final day of filming, and the losses that they had there in terms of the sets and things of that nature. Foreign insurance, if they're outside of the country, aircraft and water insurance, if you're using any kinds of those equipments within the film, and then errors and omissions insurance for producers. And the E&O insurance can be very, very important, especially for IP issues, trademarks, and copyrights, and make sure that there isn't any of those infringements that are going on. Okay, so here are some examples. This is Sonia Nasri Cole. She was directing a movie in Afghanistan that was critical of the Taliban. It was called The Black Tulip. And what they did was militants actually came in and cut off the feet of her lead actress. And so she could not find insurance to do that film, and she ended up becoming the lead actress after her lead actress got hurt to finalize that. Sometimes there are also little laws about what you can and cannot film. So for example, can you film US or foreign currency? Or should you make currency props? And you have to be careful about this. For most countries, you can film the actual currency, and it is recommended that you use actual currency because you don't want to be in violation of any counterfeit currency acts or laws that may be out there. But there are some countries that say you just cannot film it. So make sure you know the laws in that specific country. And that's just an example, that of the currency. But there could be other things. For example, filming very famous works of art or architecture, the Louvre or the Eiffel Tower, or St. Petersburg and Moscow. You have to get special permissions, special licenses, special permits to be able to film there, and that's very, very important to have, okay, and to know. The international market is very interesting because not only is it a distribution location, it could also become a source of funding, and also a source for original material. So a place to acquire rights for that. You've got some links in your handout that you can go and take a look at what that international film industry looks like. We have some major film business centers, the US, Nigeria, Hong Kong, and India. And we have to keep in mind that India is distinct from Bollywood, right? The idea of Bollywood are films that are made in Bombay, and actually in India there are many different areas that have become center to movie making, and it depends on the particular language. So in Bollywood, most of the movies would be made in Hindi, but you do have other places where they're using different languages like Urdu or others, okay? So you want to be careful that if you do have a project that's in India, that you know what area of India that it may be. But, films come from everywhere. Those might be the film business centers where the finance is really going on. But we have films coming from all different countries, and it's really wonderful when you see the Oscar nominations for the best foreign film, for example. But there are so many more that are out there. And if you do get a chance to go to like one of these, like the Asian Film Festival or the South American Film Festival, and then you get to be exposed to some of these movies that you would just never know were even existing. Netflix and Hulu are great for that as well, to see movies from other countries. So there are new centers that are developing all the time. You see here the Doha Tribeca Film Festival is a new one that's come up, but it's definitely something for you to see. Okay, I also have some resources here, the Lawyers for the Creative Arts. There are those kind of organizations just about in many, many states. So New York has the New York Lawyers for the Arts. In Georgia, it's the Georgia Lawyers for the Arts. So take a look in your state and see if there is some kind of organization that deals with lawyers for the arts. And although they're meant to sort of offer low fee or pro bono services to the art industries, it's also a great place to get resources. So if this is a new area for you in entertainment law, They usually have a library, which will be great for you to sort of peruse, spend some time, read up on stuff, and they'll also have a roster of attorneys that they're working with so that you can also ask for some courtesy interviews and talk with them. It's always great to talk to other attorneys who have been doing this for a while, especially if you're new. Most of them are more than happy to talk to you and exchange some war stories and create those relationships. Also, the bar associations of your states will usually have a section dedicated to entertainment law. It might be sports and entertainment, might be just entertainment, might be under the intellectual property. That's another great place for you to go and network and meet other attorneys and learn from them as you go forward, okay? Legal issues in film production. As you know, I told you I was giving this out for you, but these legal issues sort of expands on that handout, and that's what this is. This is the Lawyers for the Creative Arts in Chicago put this together. It is a much more expanded than my little checklist, but it's a great resource for you to go and have that information. Okay, so now I want to update a little bit on documentaries, because one of the things to keep in mind is that, filmmakers who do documentaries usually say that part of the reasons why they do them is for the public interest. There's something important that the public needs to know. They're mainly nonfiction, right? They're not fictionalized. This is about what's happening, some real issue that's out there. But you have to keep in mind that sometimes there's this crash because of that public interest and copyright owners. And so you have a lot of arguments for fair use, that we should be able to use the intellectual property of others because this is for public interest, but it doesn't necessarily work out that way. So you have to be careful that you're doing the right clearances for your documentary clients and that they are paying the right fees for it. So for example, if you do have a scene where they are singing happy birthday, you are going to have to pay a royalty for that. Trademarks, be very careful about showing trademarks. That's why a lot of times you'll see the documentaries and the hat will have the logo sort of blurred out, or even the t-shirt blurred out, because you have to be careful about trademark use in that. And then there are privacy concerns, because sometimes the documentary is about one individual, but as they go and record this individual, he might come in contact with others, and how can their privacy be protected? So there is a very famous sort of example that I use with my students where I say, there was this one gentleman who created a documentary about his parents, and it cost him about $481. When HBO wanted to sort of broadcast this, it then cost them over $400,000 to do the clearances to be able to show it. And one of those clearances was happy birthday. So you want to be careful about that for that. So now we're going to switch gears a little bit. I want to delve directly into television for a few moments. And we have network television, ABC, NBC, CBS, or Fox, right? Those are the ones that supposedly you could just get off the air. Now you need that converter box. We have cable and satellite, HBO, Showtime, Disney. We have on-demand and pay-per-view. We have DVD rentals in places like Redbox, so you do not necessarily have to go to a place like Blockbuster anymore. You're able to get it right from sort of a vending machine. Netflix and Hulu, which is all this digital streaming that's coming through our internet. High definition television, HD TV, and then 3D TV, and soon we're going to see probably a 4D TV, which I have no idea what that may look like. But recently I've listened to a wonderful presentation by Brian Wassum on augmented legalities, and you can just Google Brian Wassum. He has a blog, wassum.com, WASSOM, and he was looking at all of this new technology like the Google goggles and being able to record things while you're looking at them all the time, and how though that technology is going to bring new legal questions up in terms of privacy and stuff. So that is a great one to just go look out for. Brian Wassum, wassum.com. Augmented legalities is what he calls it. He actually has an ebook out there, so you can download fascinating stuff. Wonderful. Okay. But some terms that you need to know about television, things like a first run of a series, a pilot, syndication or reruns, network affiliation agreements, and then the marketing or the advertising dollars. With television, very similar in many ways to film when you're trying to get that idea made into something real. So you have the idea and concept. You might have an inquiry letter going out to the network or a production company. You'll notice that a lot of times networks and production companies will say they will not accept unsolicited submissions or manuscripts, and they're just trying to prevent that idea theft issue from happening. Or sometimes they'll say, you can pitch to us, but you have to sign off on this agreement, this submission agreement, where it says, you're not trying to sell it to them and they can do anything that they want with that idea. Most of the time what you'll see now is that production companies actually prefer to have an entertainment attorney call and make the inquiry for their client. And then that gives credibility to the client that they're sophisticated enough to have some form of protection with that. Okay, there is a pitch, and here, sometimes it's called a pitch on paper, sometimes it's oral when it's given, sometimes it's a little sizzle reel, a little video to sort of bring some pizzazz to the idea. A log line is basically sort of 2 lines that say what that show concept is about, a synopsis, and then a treatment, which may go more into details for each week, what it's going to look like. There are pitch festivals, places where your clients can go if they have a screenplay or a television show idea, and it's a day or maybe 2 or 3 days events, and they can go and meet people and sort of pitch. There's the Great American Pitch Fest, there's PitchCon from NAPTY, there's Kidscreen if it's a children's or families programming, and that one's in New York. So there are lots of these, but you have to take a look at them and see who's actually attending and whether it's worth the time to go. Sometimes I like to send clients so that they can get experience in pitching, not necessarily that they might actually get a buy out of it, but at least they get experience in talking about their project and how to present it, and that can be valuable in and of itself. Now, there is the Writers Guild Basic Agreement for television. There might be a development agreement, okay? I also have some information here about ratings and the Nielsen Company. I'm going to skip that and just leave that there for you. There's some links there that you can take a look at. We do have some international markets information here again. Reverse engineering of shows. So we had the BBC had Being Human, and then it came over to Sci-Fi as Being Human. And it's really interesting if you ever get the chance, and you can do this on like Netflix, for example. They have the BBC version and then they have the US version. And if you watch them, you can really see the cultural differences in them and what makes it work in each of those countries that just would not come across, So it's just something to take a look at. Things like Sesame Street also, and how that gets converted, and the ancillary markets. Now, one thing that I do want to touch base before we end our session is the FCC, the Federal Communications Commission, because this is really important. They regulate the rates and the licenses for the air license, for example. Cable systems are not licensed. Broadcast licenses are, and they have to be renewed every 5 to 10 years. There are things like registration and enforcement, and so it's really important if you're going to be in this industry that you get the updates from the FCC to see what's happening there. Okay, there was the Cable Act of 1984, and so if you heard of black boxes and things, that falls in there. The issues of piracy. This was a big thing in January of this year when SOPA and PIPA, SOPA was the Stop Online Piracy Act and PIPA was the Protect IP Act. And these were 2 acts that were about to be passed by Congress. And it sort of pitted content creators like Hollywood, Viacom, all of these studios against content channels, the technology that actually carries it, so sort of Google and YouTube and there was some concern that if these bills pass, it would just be too much, right? I mean, it would mean jail time for some of the executives from some of these places like Google and Facebook, and so we actually had a blackout. The technology companies went out to the internet, told people about them, and we had a blackout. Google blacked out its headline, Wikipedia, and all that. So you might have remembered some of that. Okay, I have the link there so that you can keep up to date on any new cases from the FCC. And then also, I have some information here about indecency and the new case that came out of there. So that's something that you want to take a look at, especially if your client is doing anything that's sort of risque. The issues of, is it indecent versus is it obscene? Okay, and whether something can be censored or banned based on those definitions. Now, we know that those definitions are community standards, so you want to be careful again of where you're at. What state that you're filming this, and who the audience ultimately is going to be. I also have here the issue of court television and these reality shows, about what are some of the legal or ethical barriers to them when you're showing a court scene on television, if it's a not scripted, but more like made for television, like People's Court, versus Court TV, who's showing sort of the proceedings as things are happening. You have here the Casey Anthony and, of course, the O.J. Simpson cases that came up there, versus something like Judge Judy. That's much more, it's made for television versus it's just the real thing. People have questioned, whether showing these proceedings perjure or are prejudiced against the defendant or against the victim, and those kind of cases. Does it sensationalize things? Is it appropriate to have that kind of access to it? So those are the debates that are still happening. Reality TV is a big thing. One of the questions that came out was whether reality TV formats can actually be copyrighted, and so we had a case of the Big Brother versus ABC's The Glass House. That was a copyright case that came up. 2 reality shows, 2 homes, 2 people inside a house and doing stuff. And at the end, it was decided that no, there wasn't a copyright infringement. The case was dropped. But there also are other issues that come up with reality shows. So competition shows, you see here, I give you the link of sort of one example. This is season 11, registration and audition rules for American Idol. And take a look at it so you can see just how all-encompassing the rights are for these. Okay. There are some other additional resources that I put up there. Another great place to visit is the South by Southwest. It happens every year in Austin, Texas. There are actually 3 tracks, interactive, digital and interactive, which includes social media, film, and then there is the music track. Most people know South by Southwest by music, but there is this film category track that runs sort of in between those, and so it's a great place to go and network and learn a little bit more about the industry, even though it's so far from Hollywood, right? But it is an excellent resource. Well, I hope you enjoyed our time together and this session. Of course, if you have any questions, you can certainly send me an email, and go and enjoy the movies. Bye-bye.